Hello, I'm Casey Welch, and we're going to continue the discussion of John Fuller and my book, American Criminal Courts, Legal Process and Social Context. In this chapter and video, we discuss the roles and process of the appellate court system. Appeal courts are considered the higher court within the judicial hierarchy, even though they hear fewer cases. There's about 100,000 appeals per year. That's out of the 1 million felony convictions. An appeal is usually, not always, but usually a post-conviction remedy in which the defendant convicted in trial asks the higher court to review the trial court procedures. Most of the appeals, about 70%, challenge the sentence only, not the conviction. So they're not contesting being guilty, just that the sentence was too harsh. Although not specified in the Constitution, the first appeal, or direct appeal, as it is also called, is generally considered the right of somebody who is convicted at trial. And that's an important point, that they're convicted at trial. Appeals after the first one are discretionary, and the higher appellate courts can choose not to hear those. But a defendant who pleads guilty does not have a right to an appeal. He or she waives that right. And it's generally considered that about 90% of the convictions in the United States are the result of a guilty plea. So the vast majority of convictions can't even get to an appeal. But when a case does go to an appeal, the appellate court has the role of review. And there's two types of reviews. First, and most common, is they review the procedures of the criminal trial court or the final judgment of the criminal trial court. This is not a retrial. The appellate court is not listening to new facts. They do not hear from the trial witnesses. They do not use a jury. And they usually do not even declare guilt or innocence. All they're looking at was whether the procedure in the trial was fair. This power of review is often called the error-correcting function of appellate courts because they identify errors and then they correct them sometimes. It also allows the courts to be self-correcting, internally self-correcting. Less often is the type of review where the appellate courts will actually review the constitutionality of a law. And this happens when the defendant appeals and says, not that my rights were violated during the process, but that I was harmed by an unconstitutional law. If the appellate court agrees with the defendant or the petitioner in such a case, the appellate court will strike down or alter that law or policy. This is part of the lawmaking function of the appellate courts. Both types of review, the review of the procedures and the review of law, establish precedent, which means that the lower courts must follow that decision. Now, as far as the decisions or the rulings go of appellate courts, there are broadly speaking three types, and some variation within. First, appellate courts can affirm the trial court, and this is what happens in 75% of the appeals. This means that the trial court agrees with the ruling of the appellate court agrees with the ruling of the trial court and says that there was no significant constitutional error, and they let the ruling stand. Some cases result in a reversal, and this means that the appellate court says that there was a constitutional problem with the procedures, but they don't throw the case out. Rather, most reversals are coupled with a remand. So it's a reverse and remand, and that means they send the case back to the same trial court for either a new trial or a resentencing. What's ironic and perhaps tragic about this for some defendants is that sometimes a defendant will win on appeal, have the case reversed and remanded, and then in the resentencing receive a more significant or a stiffer punishment. So they win on appeal, but they ultimately lose in the end. The least common appellate ruling is a dismissal. And this is, in fact, where the Supreme Court or the appellate court rules that the trial court made such a significant and harmful error that the entire case needs to be thrown out. And the person actually does walk free, usually in that case. But let's look at why there are so many affirmations and so few dismissals. And this is because of the principle of judicial restraint. A lot of people in the United States get angry about what's called judicial review or judicial activism. They think that the appellate courts overstep their boundaries. But just as problematic is the idea that the Supreme Court and the appellate courts are too restrained or too conservative. And they are restrained because they operate under various presumptions. For instance, they operate under the presumption of legality of the trial court procedures. So they start off assuming that the trial court made no error. They also operate under the presumption of constitutionality. Again, they start off with the presumption that the state laws and federal laws are constitutional. So now the question is this the right thing to do? When the appellate courts and the Supreme Court face something that seems pretty obviously to be unjust, should they exercise restraint? And there are two situations that we'll talk about where restraint has allowed injustice to remain. First, regarding mandatory minimums. The Supreme Court has consistently ruled that state laws that have mandatory minimums, as well as federal laws that have mandatory minimums, are not a violation of the Constitution's Eighth Amendment prohibition of cruel and unusual punishment. Therefore, states are allowed to keep them. And four prominent cases in this area. There's the Rummel versus Estelle case, where the Supreme Court upheld a life sentence for a felony fraud crime amounting to $120.75. There was the Harmelin versus Michigan case, where the Supreme Court upheld a life sentence without the possibility of parole for possession of 672 grams of cocaine. The Lockyer versus Andretti case, the Supreme Court upheld a 50-year sentence for a petty theft of $150 worth of Kmart toys. And then finally, there's the Ewing versus California case, where the Supreme Court upheld a 25-year sentence for the theft of 3 golf clubs worth $1,200. Most people would consider these punishments disproportionate to the crime, and therefore a violation of the cruel and unusual standard. The Supreme Court has restrained itself and allowed those state laws to stand. More glaring injustice is seen when the Supreme Court allows an execution of somebody who very well might be innocent. In the Herrera versus Collins case, Herrera was convicted of killing 2 police officers. Years later, while on death row, he presented evidence in a habeas corpus petition, convincing evidence, that his brother had committed the crime. The court, however, the Supreme Court, refused to even hear that appeal. Chief Justice Rehnquist wrote for the majority that the appeal court's process corrects only violations of the Constitution, not errors of fact in the trial. He further reasoned that court logistics and legal finality are more important than fairness beget at a trial. He wrote, quote, "Due process does not require that every conceivable step be taken at whatever cost. To conclude otherwise would all but paralyze our system for the enforcement of the criminal law," close quote. Justice Blackmun wrote a very strong dissent, and in that dissenting opinion he stated, quote, "The execution of a person who can show that he is innocent comes perilously close to simple murder. Nothing could be more contrary to contemporary standards of decency or more shocking to the conscience than to execute a person who is actually innocent," close quote. Herrera, in fact, was executed 4 months later, maintaining his innocence up to his final words. So now the question still remains for the United States, as well as for these particular cases, should the appeal courts review glaring injustices, or should they exercise restraint and allow those laws and those rulings to stand? That's something that the U.S. court system is going to continue to struggle with. Thank you for joining our discussion of the appeals court process in the criminal trials. In our next video, we're going to learn about the juvenile justice system. Thank you.